Question 1. In a high-stakes environment where multiple challenges arise in an international business transaction, an American company enters into a contract with a foreign company. The contract includes a clause specifying that any dispute should be resolved under the laws of France and the arbitration should take place in Paris. Later, a dispute arises and the American company seeks to challenge the arbitration clause based on the principle of policy in the United States. Which of the following is the most likely outcome? A. The arbitration clause is enforceable as long as both parties agree to it, regardless of public policy concerns. B. The arbitration clause is unenforceable because it violates the public policy of the United States, as the contract was entered into with a foreign company. C. The arbitration clause may be unenforceable if the U.S. courts find that the enforcement of the clause would violate the foreign state's public policy. D. The U.S. courts will automatically enforce the arbitration clause because it is a standard international practice. Answer. C. The arbitration clause may be unenforceable if the U.S. courts find that the enforcement of the clause would violate the foreign state's public policy. Explanation. In international contracts, arbitration clauses are often enforceable under the principle of party autonomy, allowing the parties to agree on the governing law and dispute resolution mechanism. However, U.S. courts may refuse to enforce such clauses if they violate the public policy of the foreign state. For example, if enforcing an arbitration clause would contradict fundamental U.S. legal principles such as due process or unconscionability, the courts may refuse enforcement. This is consistent with the public policy exception to the recognition and enforcement of foreign arbitral awards, as outlined in the New York Convention and U.S. case law. While international commercial agreements generally favor arbitration, the public policy exception is crucial in determining enforceability. This is a balance between upholding international contractual freedom and protecting domestic legal values. Question 2. During a comprehensive review of a process that needs improvement, a dispute arises between two businesses, one located in New York and the other in California. The dispute concerns a contract formed in New York but performed primarily in California. When determining the applicable law, which approach should the court most likely adopt? A. The court will apply the law of the place where the contract was executed, as this is the default approach in conflict of laws. B. The court will apply the law of the place of performance, as this is most relevant to resolving the issues arising from the contract. C. The court will apply the law of the state with the most significant relationship to the dispute, considering the place of formation, performance, and the parties' intentions. D. The court will apply California law because the contract was primarily performed in California, and California has jurisdiction over the dispute. Answer. C. The court will apply the law of the state with the most significant relationship to the dispute, considering the place of formation, performance, and the parties' intentions. Explanation. When determining the applicable law in contract disputes, modern conflict of laws principles often focus on the most significant relationship approach rather than rigidly adhering to territorial rules like lex loci contractus, place of contract formation, lex loci solutionis, place of performance. The restatement second of conflict of laws emphasizes the importance of considering factors such as the place of contracting, the place of performance, the domicile or place of business of the parties, and the nature of the contract. In this case, while both New York and California are relevant, the court will likely apply the law of the state that has the most significant relationship to the dispute based on factors, especially the place of performance. Question 3. In a multi-location scenario where consistency requirements across jurisdictions are critical, an individual's will is contested after their death. The deceased was domiciled in Texas but owned property in both Texas and Florida. Which of the following principles is most likely to apply when determining which jurisdiction's law governs the succession of property in Florida? A. The law of Florida will govern the succession of property in Florida, as it is the situs of the property. B. The law of Texas will govern all aspects of the will and the succession of the deceased's property, including the Florida property. C. The law of the deceased's domicile will govern the succession of all property, regardless of its location. D. The law of Florida will govern only the Florida property, while Texas law will govern the Texas property. Answer. A. The law of Florida will govern the succession of property in Florida, as it is the situs of the property. Explanation. Under conflict of laws principles, the lex situs law of the location of the property typically governs the succession of immovable property, real property. Therefore, in the case of Florida property, Florida law will govern its distribution upon the decedent's death, while the deceased's domicile law governs personal property, property for real property located in different jurisdictions. The principle of lex situs applies, meaning the law of the jurisdiction where the property is located determines its succession. This is a well-established principle in both U.S. domestic law and international conflict of laws doctrine. Therefore, while the Texas law would govern the distribution of personal property, the Florida law controls the succession of the Florida real estate. Question 4. In a situation where an international company based in Germany enters into a contract with a supplier in the United States and the agreement is governed by German law with a forum selection clause specifying that disputes will be adjudicated in Germany, a dispute arises over the delivery of defective goods. The U.S. supplier files a lawsuit in a U.S. court claiming that the goods were defective and seeking damages for breach of contract. Which of the following would most likely be the outcome based on principles of conflict of laws and international jurisdiction? A. The U.S. court will automatically have jurisdiction because the defendant is located in the U.S. and a contract is governed by German law. B. The U.S. court will enforce the forum selection clause and the case will be dismissed in favor of German courts. C. The U.S. court will dismiss the case due to a lack of personal jurisdiction over the German company. D. The U.S. court will decide the case under U.S. law disregarding the choice of law of forum selection clause. Answer. B. The U.S. court will enforce the forum selection clause and the case will be dismissed in favor of German courts. Explanation. Under conflict of laws principles, U.S. courts generally respect and enforce valid forum selection clauses in international contracts. This is because party autonomy is a cornerstone of contract law and the parties have agreed to resolve disputes in a particular forum, in this case Germany. According to the Supreme Court's decision in the Bremen v. Zapata Offshore Company, U.S. courts typically uphold such clauses unless enforcing them would contravene public policy or make litigation unreasonable or unjust for one party. In this case, the U.S. court is likely to enforce the German forum selection clause, leading to the dismissal of the U.S. lawsuit in favor of litigation in Germany. Question 5. While analyzing inconsistencies across various units within a multinational corporation, a case arises where two parties from different jurisdictions have entered into a contract under the laws of the United Kingdom. One party alleges that the contract is invalid because it was not properly executed under the local requirements in their jurisdiction, while the other party claims the contract is valid as it was executed according to UK law. What legal principles should a court use to determine which jurisdiction's law applies to the contract's validity and execution? A. The court should apply the law of the place where the contract was executed, as this is the most straightforward approach in conflict of laws. B. The court should apply the law of the jurisdiction where the contract was intended to be performed, as this would best reflect the parties' expectations. C. The court should apply the law of the jurisdiction with the most significant relationship to the contract, considering factors such as the place of negotiation, performed, and the parties' domiciles. D. The court should apply the law of the parties' respective domiciles, as this would provide consistency and fairness in determining validity. Answer. C. The court should apply the law of the jurisdiction with the most significant relationship to the contract, considering factors such as the place of negotiation, performance, and the parties' domiciles. Explanation. In conflict of laws, the court will generally apply the most significant relationship approach when determining which jurisdiction's law governs the validity and execution of contract. This is a modern approach that balances multiple factors, as the place of negotiation, place of performance, domicile of the parties, and the nature of the contract, according to the restatement. Second, of conflict of laws. The law of the jurisdiction that has the most significant relationship to the transaction will usually apply. This approach considers the practical realities of the contract and the reasonable expectations of the parties. Question 6. In an environment where different components must interact to resolve a family law dispute involving child custody, a U.S. citizen divorces a foreign national and the custody battle for their child is litigated in both the U.S. and the foreign national's home country. The foreign national argues that the U.S. court has no jurisdiction over the matter. Which legal principle would most likely apply to determine whether the U.S. court has jurisdiction over the child custody dispute? A. The U.S. court will have jurisdiction over the custody dispute because it is the domicile of the child. B. The U.S. court will automatically have jurisdiction because the child is U.S. citizen. C. The U.S. court will lack jurisdiction because the foreign national is not domiciled in the U.S. and the child's welfare is best determined by the foreign jurisdiction. D. The U.S. court will have jurisdiction only if both parents agree to litigate in the U.S. Answer A. The U.S. court will have jurisdiction over the custody dispute because it is the domicile of the child. Explanation. In child custody disputes under U.S. conflict of laws principles, the U.S. courts generally have jurisdiction based on the domicile of the child, not merely the citizenship or domicile of the parents. This is in line with the Uniform Child Custody Jurisdiction and Enforcement Act, UCJIA, which stipulates that the home state of the child, i.e., the state where the child has lived for at least 6 consecutive months, has jurisdiction to make initial custody determinations. The UCJIA aims to prevent conflicting custody decisions and forum shopping by ensuring that the state with the closest connection to the child's well-being is the one to make custody decisions. Question 7. In a case involving cross-border defamation, an individual in the United Kingdom publishes defamatory statements about a business located in California. The business seeks to file a lawsuit in California against the individual for defamation. Which of the following factors is most important for the California court to consider when determining whether it has jurisdiction over the defamation claim? A. The California court will have jurisdiction because the defamatory statements were published on the internet, which is accessible from California. B. The California court will automatically have jurisdiction because the defendant is a foreign national. C. The California court will only have jurisdiction if the defendant has substantial ties to California, such as conducting business in the state. D. The California court will not have jurisdiction unless the defendant was physically present in California when the statements were made. Answer. C. The California court will only have jurisdiction if the defendant has substantial ties to California, such as conducting business in the state. Explanation. In defamation cases with an international component, U.S. courts, including California, apply principles of personal jurisdiction. The key consideration is whether the defendant has sufficient minimum contacts with the forum state. This is based on the due process protections under the U.S. Constitution and the International Shoe Company v. Washington case. For a California court to assert jurisdiction, the defendant must have substantial ties to California, such as regularly conducting business or targeting the state's residents. The fact that the defamatory statements were accessible in California via the internet is not sufficient by itself. There must be deliberate action aimed at California, like targeting California residents. Question 8. In a complex case involving multiple jurisdictions, an individual is seeking to enforce a foreign judgment in the United States. The foreign judgment was obtained in a European Union country and involves a contract dispute where the defendant had no significant presence in the EU. Which of the following factors is most important for the U.S. court to consider when determining whether to recognize and enforce the foreign judgment? A. Whether the foreign judgment is consistent with U.S. public policy and would not violate constitutional rights. B. Whether the defendant has substantial assets in the U.S. to enforce the judgment. C. Whether the judgment was rendered by a court in a country that is a party to the New York Convention. D. Whether the U.S. court believes the foreign court applied the correct law in its decision. Answer A. Whether the foreign judgment is consistent with U.S. public policy and would not violate constitutional rights. Explanation. Under U.S. law, the full faith and credit clause for interstate recognition of judgments and comity principles for international recognition play a role in enforcing foreign judgments. However, U.S. courts will not recognize or enforce foreign judgments if they violate U.S. public policy or constitutional rights. This includes ensuring that the foreign judgment does not contravene fundamental principles of fairness, justice, or due process. The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards provides a framework for the enforcement of arbitral awards, but the public policy exception remains a critical aspect when considering the enforcement of judgments from other countries. Question 9. During a seamless transition where continuity must be maintained, a multinational company with headquarters in the United States enters into a contract with a foreign entity for the supply of materials. The contract specifies that the law of the foreign country will govern disputes. A dispute arises over the performance of the contract and the U.S. company files a lawsuit in a U.S. court. Which of the following is the most likely outcome? A. The U.S. court will apply the law of the foreign country because the parties have agreed to it in the contract. B. The U.S. court will apply U.S. law because the dispute involves a U.S. company regardless of the choice of law cause. C. The U.S. court will dismiss the case based on forum non-convenience, finding that the case should be litigated in the foreign country. D. The U.S. court will apply the law of the foreign country, but only if the foreign law is not contrary to U.S. public policy. Answer A. The U.S. court will apply the law of the foreign country because the parties have agreed to it in the contract. Explanation. In international contracts, courts generally respect the choice of law provisions agreed to by the parties as long as they do not violate U.S. public policy. Under the principle of party autonomy, the law chosen by the parties in the contract typically governs the dispute provided that it is reasonable and not contrary to fundamental public policy. In this case, the U.S. court would apply the foreign law specified in the contract, barring any exceptional circumstances such as the foreign law being fundamentally unfair or unjust. Additionally, the court may consider forum non-convenience if the venue is inconvenient for the parties, but the primary issue is usually the choice of law. Question 10. In a situation where two parties from different jurisdictions enter into a contract governed by the laws of a third country and one of the parties defaults on the contract, a dispute arises. Which legal principle would most likely govern the jurisdiction and enforceability of the contract, and how would a court proceed in resolving this dispute? A. The court will apply the law of the place where the contract was executed. B. The court will apply the law of the country with the most significant connection to the transaction, such as the location of the subject matter. C. The court will automatically apply the law of the country in which the defendant resides. D. The court will apply international treaties to determine jurisdiction and enforceability. Answer. B. The court will apply the law of the country with the most significant connection to the transaction, such as the location of the subject matter. Explanation. In cases of international contracts, courts typically apply conflict of laws principles with a key factor being the most significant relationship to the transaction. This principle considers where the contract is to be performed, the location of the subject matter, and the domicile or place of business of parties. The restatement second of conflict of laws outlines that courts should choose the jurisdiction with the closest and most substantial connection to the dispute. International treaties or specific clauses in the contract may influence the outcome, but the court generally avoids an automatic application of the defendant's domicile law. Question 11. In a case involving cross-border defamation where a business located in the U.S. is harmed by statements made by an individual in the U.K. on social media, what factor will be most important in determining whether a U.S. court has personal jurisdiction over the defendant? A. The U.S. court will have jurisdiction because the statement was made on a globally accessible platform, regardless of the defendant's location. B. The U.S. court will have jurisdiction because the defamation harmed the business in the U.S. and affected its reputation. C. The U.S. court will automatically have jurisdiction because the defendant is foreign national. D. The U.S. court will not have jurisdiction unless the defendant is physically present in the U.S. when the defamation occurred. Answer. B. The U.S. court will have jurisdiction because the defamation harmed the business in the U.S. and affected its reputation. Explanation. The minimum contact standard is applied to determine personal jurisdiction in defamation cases. Under U.S. law, personal jurisdiction over a defendant can be established if the defendant's actions are purposefully directed at the forum state, in this case the U.S., and cause harm there. The effects test, as established in the Calder v. Jones case, allows U.S. courts to assert jurisdiction if the defendant's conduct intentionally targets a U.S. resident or business, even if the defendant is located outside the U.S. The harm caused to the business's reputation in the U.S. would establish the necessary connection for jurisdiction. Question 12. When two companies from different countries enter into a contract and a dispute arises over breach of contract, which legal principle is most likely to determine the enforceability of a foreign judgment in the U.S. court, and how should the court proceed? A. The court will enforce the foreign judgment automatically if the defendant is a foreign national. B. The court will examine whether the foreign court had jurisdiction over the matter and whether the judgment violates U.S. public policy. C. The court will only enforce the foreign judgment if the parties have agreed to arbitrate in the foreign jurisdiction. D. The court will disregard the foreign judgment if the case involves a U.S. business. Answer B. The court will examine whether the foreign court had jurisdiction over the matter and whether the judgment violates U.S. public policy. Explanation. Under comity, U.S. courts generally recognize and enforce foreign judgments, but only if the foreign court had proper jurisdiction and the judgment does not violate U.S. public policy. This process involves a two-pronged test: 1. Whether the foreign court had jurisdiction over the parties or subject matter, and 2. Whether enforcing the foreign judgment would conflict with fundamental principles of U.S. laws such as fairness, due process, or public policy. U.S. courts typically do not enforce foreign judgments that are found to be prejudicial to the rights of the defendant under U.S. constitutional principles. Question 13. In an international contract where one party breaches the agreement by failing to deliver goods on time, what principle would most likely govern the resolution of the dispute, and how would a court determine the appropriate remedy? A. The court will apply the doctrine of specific performance and order the breaching party to deliver the goods. B. The court will apply the laws of the jurisdiction where goods were delivered, regardless of the governing contract law. C. The court will apply the principle of compensatory damages, aiming to place the injured party in the position they would have been in had the contract been performed. D. The court will automatically cancel the contract and refund any paid by the injured party. Answer. C. The court will apply the principle of compensatory damages, aiming to place the injured party in the position they would have been in had the contract been performed. Explanation. In breach of contract cases, courts generally apply the principle of compensatory damages, which aims to put the injured party in the position they would have been in if the contract had been properly performed. Specific performance, forcing the breaching party to deliver the goods, is remedy typically reserved for cases where monetary damages would be insufficient, such as when the subject matter of the contract is unique. In international contracts, courts will typically apply this principle even if the contract is governed by foreign law, as compensatory damages are a universally recognized remedy in contract disputes. Question 14. When an individual enters into a contract with a company based in another country and the company fails to perform under the terms of the agreement, what factor would a U.S. court most likely consider when deciding whether to enforce the contract, and how would this impact the outcome of the case? A. The court will enforce the contract regardless of the foreign jurisdiction's laws. B. The court will consider the forum selection clause to determine whether the dispute should be adjudicated in the foreign jurisdiction. C. The court will only enforce the contract if the foreign company has assets in the U.S. D. The court will disregard the contract if the performance was scheduled outside the U.S. and did not occur in the U.S. Answer. B. The court will consider the forum selection clause to determine whether the dispute should be adjudicated in the foreign jurisdiction. Explanation. In international contracts, forum selection clauses play a crucial role in determining which court will have jurisdiction over disputes. U.S. courts generally respect such clauses unless they are unreasonable, unfair, or against public policy. If the contract specifies a foreign jurisdiction for disputes, the U.S. court may dismiss the case in favor of the designated forum, provided that the clause is valid and enforceable under both U.S. and foreign laws. This ensures that parties' contractual expectations regarding dispute resolution are honored. Question 15. In a case involving a company based in the U.S. that enters into a contract with a foreign entity for the provision of goods and a dispute arises over the contract's validity, what factor will the court consider when determining the applicable law and jurisdiction to resolve the dispute? A. The court will apply the law of the country in which the goods were to be delivered. B. The court will automatically apply the law of the U.S. because the company is based there. C. The court will apply the law of the jurisdiction specified in the contract unless doing so would violate U.S. public policy. D. The court will disregard the contract and apply international treaties to resolve the dispute. Answer. C. The court will apply the law of the jurisdiction specified in the contract unless doing so would violate U.S. public policy. Explanation. Parties to a contract generally have the freedom to choose which jurisdiction's law will govern their agreement. U.S. courts typically enforce this choice of law provision unless it violates public policy. The party autonomy principle is central to international contract law, and courts will usually respect the parties' agreement regarding the law that governs their contract as long as that law is not incompatible with U.S. law. If there is choice of law clause in the contract, it will generally dictate the law that applies. Question 16. When two parties from different jurisdictions enter into a contract and one party fails to perform under the contract, what legal doctrine will most likely govern whether the contract can be enforced in a foreign court, and how will a court proceed with enforcement? A. The court will apply the doctrine of forum non conveniens to determine whether a case should be heard in the foreign jurisdiction. B. The court will apply the doctrine of act of state, considering the actions of a foreign government that might impact enforcement. C. The court will enforce the contract based on the jurisdiction where the contract was executed. D. The court will enforce the contract based on the international trade laws in effect at the time. Answer A. The court will apply the doctrine of forum non conveniens to determine whether the case should be heard in the foreign jurisdiction. Explanation. The forum non conveniens doctrine allows a court to decline to hear a case if another court, typically in a foreign jurisdiction, is deemed to be a more appropriate forum for resolving the dispute. This often happens when the case involves parties or events located in another country. Courts apply doctrine by weighing factors like the convenience of the parties' access to evidence and whether the foreign jurisdiction has a sufficient interest in adjudicating the dispute. Question 17. In a case where a company based in the U.S. enters into a contract with a foreign company for the supply of materials, and the contract specifies that any dispute will be resolved under international arbitration, which principle will govern the enforceability of the arbitration award? A. The court will automatically enforce the arbitration award under the New York Convention, as both countries are parties to it. B. The court will enforce the arbitration award only if the arbitrator's decision is consistent with U.S. law. C. The court will not enforce the arbitration award unless the parties are domiciled in the same country. D. The court will disregard the arbitration award if it finds any legal irregularities during the arbitration process. Answer A. The court will automatically enforce the arbitration award under the New York Convention, as both countries are parties to it. Explanation. The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards is an international treaty that provides a framework for enforcing arbitration awards across borders. If both countries are parties to the treaty, the U.S. court is obligated to enforce the award unless there are grounds for refusal, such as fraud, lack of due process, or violation of public policy. The Convention seeks to promote the uniform recognition of international arbitration awards, ensuring that parties can resolve disputes outside of national courts with confidence that the award will be enforceable internationally. Question 18. In a case involving a cross-border contract dispute, one party claims that the contract is void due to a lack of proper execution according to local law, while the other party argues that the contract is valid under the governing law chosen in the contract. Which legal principle would the court most likely apply in determining the enforceability of the contract? A. The court will apply the governing law specified in the contract, assuming no violation of public policy occurs. B. The court will apply the law of the country where the contract was executed, as this determines the validity of the contract. C. The court will automatically disregard the governing law clause if there is a significant discrepancy between the two jurisdictions' laws. D. The court will apply the law of the jurisdiction where the breach of contract. Answer A. The court will apply the governing law specified in the contract, assuming no violation of public policy occurs. Explanation. Under conflict of laws principles, U.S. courts generally honor the party's choice of law in international contracts, unless enforcing the chosen law would violate U.S. public policy. Party autonomy is a central tenet of international contract law, meaning the law specified in the contract is usually applied unless there are compelling reasons, such as overriding public policy concerns, to disregard it. Courts typically respect the choice of law clause unless it would lead to an unjust result, such as the enforcement of terms that contravene the fundamental legal principles of the forum jurisdiction. In this case, court would likely apply the chosen governing law and assess the validity of the contract under that legal framework. Question 19. When a business in the U.S. enters into a joint venture agreement with a foreign company and a dispute arises over the scope of the agreement's performance, what principle will the court most likely apply to determine how the parties' contractual obligations should be interpreted? A. The court will apply the principle of contra pro forentum, interpreting any ambiguous terms in favor of the party that did not draft the contract. B. The court will apply the principle of good faith and fair dealing, interpreting the terms in a manner that reflects the parties' intent to cooperate in the joint venture. C. The court will automatically interpret the contract using the law of the country in which the business is domiciled. D. The court disregard the contract terms and enforce the agreement based on general principles of equity. Answer: B. The court will apply the principle of good faith and fair dealing, interpreting the terms in a manner that reflects the parties' intent to cooperate in the joint venture. Explanation: when interpreting the terms of joint venture agreement, courts often apply the principle of good faith and fair dealing, which requires the parties to act honestly and fairly in fulfilling their contractual obligations. This principle is particularly important in joint venture, where cooperation and mutual trust are essential. Courts will interpret the contract in a way that reflects the parties' reasonable expectations and the purpose of their agreement. This principle overrides strict formalities when interpreting ambiguous terms, focusing on ensuring that the parties act in manner consistent with their mutual intent. Question 20. In a dispute between a U.S.-based company and a foreign company over a breach of contract, what factor would most influence whether the U.S. court would apply the principle of forum nonconvenience and decline jurisdiction over the case? A. The location of the contract's performance is in the U.S. B. The court will apply forum nonconvenience if the case involves U.S. businesses and foreign parties, regardless of where the contract is performed. C. The court will apply forum nonconvenience if the case would burden the U.S. legal system, such as when witnesses or evidence are primarily located abroad. D. The court will apply forum nonconvenience if the foreign company has not entered the U.S. market. Answer: C. The court will apply forum nonconvenience if the case would burden the U.S. legal system, such as when witnesses or evidence are primarily located abroad. Explanation: the forum nonconvenience doctrine allows courts to decline jurisdiction if another forum would be more convenient and appropriate for hearing the case. U.S. courts will apply this doctrine if the forum is considered inconvenient and if the case involves significant foreign elements, such as witnesses, evidence, or the location of the contract's performance being outside the U.S. The court would assess the relative convenience of the foreign forum and whether maintaining the case in the U.S. would unnecessarily burden the legal system. This doctrine is meant to ensure that cases are heard in the most appropriate jurisdiction for the parties in the dispute. Question 21. In an international dispute where a party seeks to have a foreign judgment recognized and enforced in the U.S., what legal standard will the court apply when determining whether the foreign judgment should be recognized? A. The court will apply a reciprocity standard, recognizing the judgment only if the foreign jurisdiction would recognize U.S. judgments in similar circumstances. B. The court will apply a substantial similarity standard, recognizing the judgment only if the foreign country's laws are similar to U.S. laws. C. The court will apply the public policy exception, recognizing the judgment unless it contravenes fundamental principles of U.S. law. D. The court will automatically recognize the foreign judgment without any additional analysis. Answer: C. The court will apply the public policy exception, recognizing the judgment unless it contravenes fundamental principles of U.S. law. Explanation: when determining whether to recognize a foreign judgment, U.S. courts will generally enforce it under the principle of comity as long as it does not violate U.S. public policy. This means that U.S. courts will recognize and enforce foreign judgments unless doing so would infringe on fundamental legal principles such as fairness, justice, or due process. If the foreign judgment is found to be incompatible with U.S. public policy, or if the foreign court did not provide proper procedural safeguards, U.S. courts may refuse to enforce the judgment. The reciprocity principle may also be relevant, but the public policy exception is typically the primary consideration. Question 22. In a case where a U.S. business has entered into an agreement with a foreign entity for the supply of services and a dispute arises over the breach of contract, which principle will most likely govern the jurisdiction in which the dispute should be adjudicated? A. The court will automatically apply the law of the country where the services were performed. B. The court will examine the forum selection clause in the contract to determine the appropriate jurisdiction. C. The court will always apply U.S. law because the business is domiciled in the U.S. D. The court will refuse jurisdiction if the defendant is located outside the U.S. Answer: B. The court will examine the forum selection clause in the contract to determine the appropriate jurisdiction. Explanation: the forum selection clause in a contract is the primary determinant of which jurisdiction will hear disputes arising from the contract. If the contract specifies a particular forum jurisdiction, U.S. courts will generally respect that clause unless enforcing it would be unreasonable or unjust. Courts will evaluate the clause for fairness and ensure it is not the result of undue influence or unequal bargaining power. This clause provides predictability for the parties by specifying the location and legal framework for dispute resolution, which is particularly important in international contracts. Question 23. When a party from a foreign country breaches a contract with a U.S. company and the contract includes an arbitration clause specifying the use of a foreign arbitration institution, how will a U.S. court typically handle the enforcement of an arbitration award rendered by the foreign institution? A. The U.S. court will not enforce the award unless the foreign institution's arbitration process strictly adheres to U.S. procedural rules. B. The U.S. court will automatically enforce the award if the arbitration clause specifies foreign institution, regardless of procedural fairness. C. The U.S. court will enforce the award under the New York Convention unless enforcement would violate U.S. public policy. D. The U.S. court will disregard the award and proceed with new trial to resolve the dispute. Answer C. The U.S. court will enforce the award under the New York Convention unless enforcement would violate U.S. public policy. Explanation: under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, U.S. courts generally enforce foreign arbitration awards provided they meet certain conditions. These conditions include the procedural fairness of the arbitration process, the agreement to arbitrate, and the compatibility of the award with U.S. public policy. U.S. courts will typically enforce an award unless there are specific grounds for refusal, such as fraud, lack of due process, or a conflict with public policy. This ensures that international arbitration awards are upheld, promoting consistency and trusting cross-border dispute resolution. Question 24. In a case involving a breach of contract between a U.S. company and a foreign company, which principle will a U.S. court most likely apply when determining whether the foreign company can be compelled to arbitrate the dispute in the U.S. A. The court will apply the minimum contacts test to determine whether the foreign company has sufficient connections to the U.S. to compel arbitration. B. The court will apply the enforcement of arbitral awards principle requiring the foreign company to arbitrate regardless of jurisdiction. C. The court will only compel arbitration if the parties have a signed contract specifying U.S. based arbitration. D. The court will refuse to compel arbitration if the foreign company objects to the jurisdiction of U.S. courts. Answer A. The court will apply the minimum contacts test to determine whether the foreign company has sufficient connections to the U.S. to compel arbitration. Explanation: when determining whether a foreign company can be compelled to arbitrate in the U.S., the court will apply the minimum contacts test, which assesses whether the foreign company has sufficient purposeful availment of the U.S. legal system. This includes analyzing whether the company has engaged in business activities in the U.S. or has purposely directed actions towards the U.S. that justify the application of U.S. jurisdiction. If the foreign company has such contacts, U.S. courts may compel arbitration under the Federal Arbitration Act and international agreements, such as the New York Convention, if the contract specifies arbitration in the U.S. Question 25. When two companies from different countries enter into a contract with an arbitration clause and one party later breaches the contract, how will the U.S. court typically approach the issue of enforcing the arbitration clause in favor of the non-breaching party? A. The court will automatically enforce the arbitration clause regardless of the circumstances. B. The court will analyze whether the arbitration clause is enforceable under the Federal Arbitration Act and international treaties such as the New York Convention. C. The court will disregard the arbitration clause and adjudicate the dispute according to local laws. D. The court will enforce the arbitration clause only if both parties are U.S. citizens. Answer B. The court will analyze whether the arbitration clause is enforceable under the Federal Arbitration Act and international treaties such as the New York Convention. Explanation: under the Federal Arbitration Act, FAR, U.S. courts will generally enforce arbitration clauses in international contracts provided the clause complies with the requirements set forth by both the FAR and international treaties such as the New York Convention. The New York Convention specifically provides a framework for the recognition and enforcement of foreign arbitration awards, facilitating international commercial dispute resolution. Courts will typically respect arbitration clauses as long as they were mutually agreed upon by the parties and not obtained through fraud, duress, or undue influence. Additionally, the enforcement of arbitration clauses may be subject to certain exceptions, such as if the clause would violate U.S. public policy or if there are significant issues with the fairness of the arbitration process. Question 26. When a foreign party in a commercial contract involving a U.S. company defaults on their payment obligations, what is the most likely recourse for the U.S. company to pursue in terms of dispute resolution? A. The U.S. company can file a lawsuit directly in U.S. courts regardless of the location of the foreign party. B. The U.S. company will have to engage in arbitration even if the foreign party has not agreed to an arbitration clause. C. The U.S. company can seek redress through the United Nations Convention on Contracts for the International Sale of Goods (CISC) if both parties are signatories. D. The U.S. company can file a lawsuit in a foreign court to seek resolution. Answer C. The U.S. company can seek redress through the United Nations Convention on Contracts for the International Sale of Goods (CISC) if both parties are signatories. Explanation: the CISC provides a standardized legal framework for the international sale of goods which governs contracts between parties in different countries. If both the U.S. company and the foreign party are signatories to the CISC, the U.S. company can seek redress under its provisions, which cover breach of contract and remedies. The CISC is designed to simplify international trade by providing clear guidelines on contract formation, performance, and dispute resolution. However, it does not cover all types of contracts, and the parties can opt out of its provisions if they agree to another legal framework such as arbitration. If the contract does not fall under CISC, other dispute resolution options would be considered. Question 27. What principle governs the enforceability of a contract that contains a choice of law clause specifying that the laws of a foreign country will apply, but the contract is performed in the U.S.? The U.S. court will always enforce the foreign choice of law clause, regardless of the location of performance. B. The court will apply the principle of public policy to determine whether enforcing the foreign choice of law clause would violate fundamental U.S. laws or principles. C. The court will apply the lex loci contractus rule of enforcing the law of the place where the contract was signed. D. The court will disregard the foreign choice of law clause and apply U.S. law automatically due to the performance taking place in the U.S. Answer B. The court will apply the principle of public policy to determine whether enforcing the foreign choice of law clause would violate fundamental U.S. laws or principles. Explanation: when a contract contains a choice of law clause specifying the laws of a foreign country, U.S. courts typically honor the clause unless doing so would contravene fundamental U.S. public policy. This principle is essential to maintaining the integrity of U.S. legal standards, especially in matters that might conflict with U.S. statutory requirements or constitutional protections. If enforcing the foreign law would lead to an unjust result, such as violating U.S. legal principles, the court may refuse to enforce the clause. However, the performance of the contract in the U.S. does not automatically invalidate the foreign law choice. Question 20. In international commercial transactions, when a party disputes the jurisdiction of a U.S. court in an international contract, what factor will most influence whether the court accepts jurisdiction? A. The forum selection clause in the contract, which specifies the jurisdiction for dispute resolution. B. Whether the U.S. company is a party to the dispute. C. The location where the contract was signed. D. The nationality of the witnesses involved in the case. Answer A. The forum selection clause in the contract, which specifies the jurisdiction for dispute resolution. Explanation: the forum selection clause in a contract is a key factor in determining jurisdiction in international commercial transactions. If the contract explicitly specifies a particular jurisdiction for dispute resolution, U.S. courts will generally respect that clause as long as it is not the result of fraud, undue influence, or other unfair practices. The court will enforce the forum selection clause unless there is a strong reason to deny jurisdiction, such as concerns about fairness, inconvenience, or fundamental legal principles being violated. This clause provides clarity for both parties and ensures that disputes are resolved in the chosen jurisdiction. Question 29. In an international business transaction, when a party seeks to enforce a contract in the U.S. that has been governed by the law of a foreign country, what factor will most likely prevent the U.S. court from enforcing the foreign contract? A. The foreign contract violates the public policy of the U.S. B. The foreign law governing the contract is incompatible with U.S. legal principles. C. The foreign party refuses to participate in the litigation process in the U.S. D. The foreign party does not have a physical presence in the U.S. Answer A. The foreign contract violates the public policy of the U.S. Explanation: a U.S. court will generally enforce a foreign contract unless it violates U.S. public policy. Public policy considerations may include issues related to fairness, morality, or statutory rights that conflict with U.S. laws. If enforcing a foreign contract would result in an unjust or unlawful outcome in the U.S., such as violating labor rights, consumer protection laws, or other fundamental legal principles, the court will likely refuse to enforce the contract. Courts will examine whether the foreign law and its enforcement would contradict U.S. legal standards before rendering a decision on enforceability. Question 30. In an international commercial contract, if a party wishes to modify or terminate the agreement before its performance is completed, what general rule will most courts apply when determining whether such a modification or termination is enforceable? A. The contract can be modified or terminated unilaterally by the performing party. B. The modification or termination must be agreed upon by both parties unless specified otherwise in the contract. C. The modification or termination will be enforced only if the original contract explicitly allows it. D. The court will automatically enforce any modification or termination regardless of the circumstances. Answer. B. The modification or termination must be agreed upon by both parties unless specified otherwise in the contract explanation. In most cases, modification or termination of a contract requires the agreement of both parties unless the contract specifies otherwise. Courts typically enforce the principle that contracts are binding and cannot be altered or terminated without mutual consent, except in cases where the contracting a termination clause that allows for unilateral modification or termination under specific conditions. Without such a clause, the agreement of both parties is generally required to modify or terminate the contract, ensuring fairness and mutual consent in commercial dealings.